How's it going, everybody? I'm back. I am not an attorney and this is not legal advice. If you want legal advice, please contact an attorney. I'm making this video because there's a lot of misconceptions out there as to when peace officers have to mirandize you. So hopefully this will kind of help you guys. It is wise for the police to read directly from the Miranda warning card instead of relying on his or her memory for the proper language. However, deviations from the standard Miranda warnings probably won't make the warnings inadequate. For example, in Duckworth v. Egan, the United States Supreme Court held that an otherwise adequate set of Miranda warnings was not spoiled by the inclusion of the statement that we, the police, have no way of giving you a lawyer, but one will be appointed for you, if you wish, if and when you go to court. However, failure to an in-custody suspect that anything he or she said could be used against him or her was a fatal error, requiring suppression of the defendant's ensuing statements. The police may tape or video record a suspect's statement without telling the suspect that he or she is being recorded. A person being interrogated does not have to be told that he or she is a suspect when given the Miranda warnings. The Miranda warnings do not have to be repeated when the subject of the interrogation turns to questioning that may incriminate the person being interrogated. Even if the person being interrogated was first told by the police that they are investigating the criminal activities of another person, the police do not have to repeat the Miranda warnings and do not have to tell the person being interrogated that he or she is a suspect if the interrogation turns to questioning that may incriminate the person being questioned. In other words, if they come and tell me, we have a suspect that has committed these crimes, or we believe that he committed these crimes, and we need you to go ahead and answer some questions, could you please help us out? No, thank you, because that means I may be the suspect and they don't have to tell me that. Miranda warnings need not be given at time of arrest. The Miranda warnings do not have to be given when a suspect is arrested or otherwise deprived of his or her freedom of action. They only have to be given prior to custodial interrogation. Thus, if after being arrested but before being interrogated, the defendant voluntarily makes incriminating statements, such statements are admissible even though the defendant never received Miranda warnings. If Miranda warnings are given to a suspect who is not in custody, those warnings may be effective once the suspect has been placed in custody and may not have to be repeated prior to custodial interrogation. So their window of opportunity is when they arrest you, and once they place those handcuffs on you, people have the misconception that they have to be Mirandized, when in fact that's not the case. The trick that they will do is they will Mirandize you once you're at the station. So anytime you say anything before that, in other words, from the time you get arrested, handcuffed, out in the street or wherever you're at, and then they drive most likely the long way to the police station, if you open your mouth and insert your foot, you're screwed. So keep that in mind, folks, and please Google Miranda versus Arizona and you guys can do more research. And please like and subscribe and let other people know about my channel, because it's all about information and knowledge is power. So Godspeed, and I hope you liked the video.